Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. We have a panel of experts assembled ready to deal with the topic that we believe will be of interest to you. It always works best if you join the conversation. For you to do so, at the bottom of your screen you see ways you can get in touch with us. Also a reminder, something that is unique about the attorneys, the firm of Hollis Wright provides attorneys standing by right now to take your calls. So at any point during this program, if you have a question you'd love to get some free, good, solid legal advice on, take the advantage and pick up the phone and give them a call. As often takes place, leading our conversation today from the firm of Allwin Horn, Josh Wright. Good to see you, sir.
Good to see you. Hope you had a great week.
I did indeed.
Thank you. Thousands of calls, texts, and emails answered every year on this television show. Wow. That's one of the things we do. We're very proud of it. It's kind of been our mission from the start 5 years ago. That we answer every call, email, and text. Sometimes it relates to the show, sometimes it doesn't relate to the show, but we're here ready to answer questions.
Take advantage of it.
So I'm glad you point that out each week.
I'm glad to do so.
You had a good week?
I did have a good week. You?
Very good week. And we're very lucky today because we've got Allwin Horn on, who is a great lawyer that does a lot of things, but he specializes in workers' comp. Not only is he a great lawyer, he's a great friend of mine personally. He's been on the show multiple times because he does such a great job. We send a lot of our workers' comp work directly to Allwin because he can lead, guide, and direct people through the process. This show ultimately is about workers' compensation, know your rights if you've been in a work-related accident. You know, one of the interesting statistics that Allwin comes up with when we do these shows is 15,000 people, roughly, per year in Alabama are injured in a work-related accident where workers' comp could be implicated. That's a lot of people.
That's a bunch of families.
That's a lot of families impacted in the viewing audience too. Right. And so that's why we bring Allwin on as much as we do. We're going to do some different spins on the show today. You like promotions like this, don't you?
Absolutely.
Is that good, by the way?
Absolutely. Anything good, any lies you want to tell about me are fine.
Well, thank you for being on the show. All right, let's kind of jump into this topic. I know we've done comp before. We're going to talk about some new things today that we haven't talked about in the past. But just in general terms, explain, because I think there's some confusion out there, Allwin, about when is an employer required to have workers' compensation insurance or some type of fund to be able to compensate you for if you're involved in a work-related accident?
Good place to start, Josh. In Alabama, just a good starting place is any employer that has more than 5 employees on their payroll, provides them a W-2, provides them wages, controls what they do, is required to have workers' compensation insurance coverage. They can get that through a private insurance carrier like most of us do, or typically with large companies, they create a fund or a self-insured fund where they actually keep part of their profits to use to manage the compensation claims. And what they're going to pay for, and we're going to get into that in more detail, is going to be the compensation portion when people are injured and out of work, and the medical portion for the medical payments for those people who need actual medical treatment as a result of their injuries.
What happens, because I know we get this question every time we do a workers' comp show, what happens if an employer who's supposed to have workers' comp insurance does not have workers' compensation
Good question.
Insurance?
I've come across this a few times in my career, and you can seek double penalty or double recovery against the employer for that. And given the low threshold or the low sums of money and benefits available under the Alabama Workers' Compensation Act, that's a good thing to get sometimes.
Talk just in general about the concept of a no-fault system, because I know it's unique. The work that I traditionally do, and you handle some personal injury-based cases, generally fault matters, and who's responsible matters, and whether or not somebody contributed to their injury is relevant and pertinent in a case to assess whether they can recover. In workers' comp, there are some of those circumstances, but for the most part, it's a no-fault system, is it not?
That's exactly right. And back in the 50s, 60s, even the early 70s, an employee could sue their employer directly for negligent acts, an unsafe, negligently kept unsafe workplace. But the Workers' Compensation Act did away with that, and what it did is you could be, the sole cause of your injury or accident. You could trip and fall down the stairs, slip on something on the floor you should have seen, resulting in an accident. And the trade-off is that while you are entitled to workers' compensation benefits for being out of work, at a percentage of your actual wages and a reduced rate, those are paid, and also your medical benefits are paid. So the trade-off is while the benefits are kept down, your medical is paid for not only during the time of your recovery, but for life, even if you're at fault for your accident, as long as your injury occurs in the line and scope of your employment.
And that was actually the next place I was going to go. You still have to prove that the employment is a component to the injury.
Absolutely. The accident or injury has to arise in and out of the scope or course of your employment. You have to be on the job doing something to further the employment. There are some exceptions, and cases are very fact specific to determine whether or not it's, quote, compensable. An injury is compensable if your accident takes place during the line, scope, and course of your employment in furtherance of of the business of the employer.
Let's take some examples, because I know we get these questions each time. Company picnic.
Company picnic, absolutely. If you're required to be there, then it would be covered.
Okay.
Absolutely.
Let's say somebody's on the way to work, and it's common for them just to drive to and from work, but it's not required for them to do anything on the way there.
That would not be covered. And now let me give you a little side note to that. Now, we've had cases where people are required to park in the company parking lot, and they get to work, but they're not in the door yet, and they fall on the way in or get hit by another car, another co-employee. Now, that would be covered. And that's what's important, and that's why it's such a good reason for people to get a lawyer, is these cases are so fact specific.
Yeah.
But anything, even lunch breaks, for example. People who are required to have lunch, they're given 30-minute lunch breaks, but they're required to have it there in the company cafeteria.
Yeah.
Then that's covered if there's an accident that takes place during that time.
Talk for a moment, because I think there's generally a concern to get a lawyer that really understands this area of the law. There's a concern that it's going to cost people out of their pocket. It doesn't necessarily work that way. They can get a lawyer on a contingency, can't they?
Absolutely. I mean, all cases with every plaintiff's lawyer that I know that does this works these on a contingency fee basis. By law, you are only entitled to a 15% fee of the recovery and reimbursement of your expenses. I don't know of anybody that charges for this. That means that if we take on a case, we put time and money into it, and we don't recover, the employee doesn't owe us anything.
Gotcha. All right, we're going to go to commercial break right now. When we come back, I want to talk, David, about an important topic, which is the quick trigger on the statute of limitations, or at least the notice that has to be provided to the employer if you're injured on the job to protect your claims.
Good deal. We'll step aside our first break of the evening. As we do take a break, a reminder of how you can get in touch with the show. We'd love to have you join the conversation. Also, live attorneys standing by right now to take your call. Would love to have you join the conversation. Take advantage of that opportunity provided to you by the firm of Hollis Wright. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys. Love the feedback we're getting. A lot of folks taking advantage of the opportunity to speak with an attorney standing by live right now. I encourage you to take advantage of that opportunity. Going to do that as long as we're on the air tonight. So a unique opportunity. Also always get some really good questions. A question we've got here: I've been injured on the job. What type of benefits am I entitled to?
Let me try to put this in a nutshell. First of all, when you're injured on the job, if you were required to come out of work for let's call it the healing period. You go to your doctor, you come out of work, you are entitled to what is called temporary total disability benefits, which is actually 2/3 of your average weekly wage. Reduced weight, but you don't have to work, and that's what you get. Now, if you are able, if your doctor say puts you on light duty or restricted duty and your employer accommodates you, you go back to work, you're doing something different, and it's less than what your average weekly wage was at the time of the injury, then the workers' compensation carrier has to pay the difference in what you were making at the time of the injury and what you're making on your light duty status. Now thereafter, eventually after the doctor gets through treating you, if you had surgery and you recover, you heal up, you may have some restrictions, you may be returned to work, but when you return to work, or you may not be able to, you're entitled to what's called a permanent partial disability rating. In other words, the doctor's treated you, you're no longer in your temporary healing time period, you have now been placed at maximal medical improvement and you've been assigned a permanent impairment rating or some form of permanent disability. But you're not 100% disabled, you're just partially disabled. You're entitled to whatever the percentage of your impairment is, or what's considered a vocational loss of access to the job market, ways to calculate it. You are entitled to those benefits for up to 300 weeks. Now, if you're 100% disabled, you cannot go back to work. Let's say you've been a diesel mechanic all your life, you have a 9th grade education, and you don't know any other trade. You're 55 years old, you can't be retrained to do anything, you can't go back to that job. You may be 100% totally disabled. And under those circumstances, you'd be entitled to 2/3 of your average weekly wage, which would be that compensation rate, that TTD rate, for the rest of your life. And we can go into, typically a court, factually, a court cannot require an employer or their insurance carrier to pay you that sum in a lump sum. They'll pay you weekly, and there are offsets involved with Social Security and disability, things of that nature, but it can be negotiated into a lump sum and managed so you can actually, if you were applying for disability or something like that, you can maximize those benefits and also maximize a lump sum settlement with your workers' compensation claim.
With the complicated nature of what you just walked through.
That's where I was headed,
Yeah, I mean, do you see people trying to do this on their own?
I do, and people try to do this on their own all the time, and especially they started in the beginning. They've had good relationships with their employers, long-time employees. They don't want to upset anybody. They don't want to rock the boat. But what people need to realize is that typically their employer is not the one making the calls on who's going to pay these claims, who's going to pay the medical, who's going to pay the temporary disability benefits. It's the insurance company. And we know some insurance companies are better to deal with than others. But at the end of the day, they're about making the money and saving the money. They don't want to pay the claims. So my suggestion is always get a lawyer. Number one, it's complicated. Number one, you back yourself in a corner. You don't know what you're doing by agreeing to things you might not should agree to when it's proposed by an insurance company or the adjuster. But then the insurance company, they're hiring lawyers. They've been trained. They're educated in the laws. You are not. We are. 15% is nothing to have somebody walk you through this.
Yeah, and I want to talk about two things. One is talk about, are there notice requirements and then statutes that are applicable? How does that work?
As in any claim in the state of Alabama, you're going to have a statute of limitations, okay? But first of all, talking about the notice, when you're injured on the job, first of all, you need to report it immediately, just because the longer you wait, it's going to give the employer more reason to say, well, this didn't happen here. A lot of people get hurt on the job. They go home, try to shake it off, and a week later there's a problem and they need to go to the doctor and, well, you didn't report it. The law says you're supposed to report it within 5 days to your employer. However, the real time frame based on some case law decisions is 90 days. So you have up to 90 days, but you need to report it immediately. If you don't file a workers' compensation claim, actually file a lawsuit in a court of law within 2 years of the date of the accident, or within 2 years of the last time you received those temporary total disability benefits, then you've waived your right to seek compensation.
Now, if you fail to notify your employer within a 90-day time frame, are you precluded from filing suit?
You are precluded. Well, let's just put it this way. I have filed cases where there may be a question whether notice was given in 90 days because my client may say, well, we did it, but they just didn't turn it into their insurance company or file the first report of injury with the state of Alabama. So you can fight it, but that is a defense to your claim. And let me say this, the employer can be put on constructive notice. For example, let's say that you have an accident, you say your injuries are job related, you go to the doctor, but the doctor is, and the employer is saying, well, this happened at home, we're not going to cover it, and then the employer monitoring your health care gets your records, and the records indicate, well, this happened at, patient says this happened at work. That's constructive notice to the employer.
And you talked a little bit about employers an employee in that relationship, and employees sometimes are fearful that they're going to be discriminated against, or they're fearful to file a claim. There are laws woven into the Comp Act that prevent retaliation, are there not?
That's absolutely correct. It's referred to as retaliatory discharge or wrongful termination. Alabama is an employee at will state. Employers don't even need a reason to terminate somebody. But if you seek workers' compensation benefits and you are thereafter terminated, which happens often, you start all of a sudden accruing points for things that you never accrued points for beforehand, and then you build up those points and you're terminated, you can file a claim for wrongful termination or dismissal from your job. However, it's a strong burden on behalf of the plaintiff. You have to prove the sole and only reason you were terminated was for retaliation for seeking those workers' compensation.
And I'm
benefits.
assuming you handle those type of
We
cases
handle
too?
those claims too, and there are a lot of good lawyers in Birmingham that handle those.
I'd be willing to bet that the value of those cases can be even greater than the comp case.
Absolutely.
Sometimes.
As we've talked about in the workers' compensation setting, you have caps on what you can get and limits on the benefits. In a retaliatory discharge claim, you get full lost wages, mental anguish, and emotional distress.
All right, I know we're going to break. David, when we come back, we're going to have a slide that pops up on the screen that is relevant to the Comp Act, and Comp Act was implemented that we're going to be talking about in 1985. We're going to talk about some price indexing, things that have changed since 1985, and that's true even though the workers' comp caps have stayed the same, and there's been a push to change that in our state. But we're going to be talking about, I'm going to leave you with one, and that is this. What was the minimum wage in 1985 versus what it is today? Be thinking about that.
A bit of a difference?
Bit of a difference.
All right, we're stepping aside our final break of the evening. As we do so, a reminder, we'd love to have you join the conversation. Also find the firm on Facebook as well as Twitter. Stay tuned, more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. Now, serving on a jury can be confusing because there's some information that the attorneys in the case aren't allowed to tell you. And in wrongful death cases, it might surprise you. In tonight's Legal 4-in-1, we're answering the question, what evidence is allowed in a wrongful death case? That's a case where one person's conduct caused the death of another. A wrongful death case is a civil cause of action for someone's death where money damages may be awarded, not jail time. In these cases, a lawyer can only talk about punishing and deterring the defendant for causing the death. That leaves out a lot of information about the person who died, including how that person's death has affected his family and his community. The reason lawyers only talk about punishing and deterring the defendant in these cases is this. In a death case, at the end of the trial, the judge will read a jury charge which says the following. The damages in this case are punitive and not compensatory. Punitive damages are awarded to preserve human life, to punish the defendant for its wrongful conduct, and to deter or discourage the defendant and others from doing the same or similar wrongs in the future. This means that in Alabama, lawyers cannot talk about how great the loss was to a person's family or friends for that death. They can't talk about lost wages or the financial impact on that person's family. Lawyers can't mention how much that person loved his wife, kids or grandkids, or what it would have meant to walk a daughter down the aisle, for example, in her wedding. In short, lawyers cannot talk about all the things that a person who died at the hands of another missed out on in his own life. In Alabama, the legislature said you can't put a value of someone's life. So as lawyers, what we can do, the only thing we can do, is ask that the defendant is deterred and punished for the wrongful conduct that caused the death in the first place. We can ask that the jury send a message, a loud message, to prevent such types of death in the future. For example, if a truck driver caused a crash where someone died, the jury can send a message by making the truck driver pay money damages. The hope is that other drivers will be discouraged from the dangerous conduct that caused the death. As attorneys, we often wish we could submit more evidence to the court about the person who died, but unfortunately, we can't. If you are ever a juror on such a case, please keep in mind what I've told you today about wrongful death cases. Remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. A competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys. Our final segment here is just a few minutes remaining for you to take advantage of the opportunity to speak to an attorney standing by live right now. I urge you to take advantage of that opportunity. Just a few more minutes remaining. Josh?
All right, so when we went to break, I kind of teased the break with this concept that there are some price indexes and some changes in pricing of certain things from fast food to purchasing cars, etc., from 1985 forward. Set the table for us here, if you will, on why that's even material.
Josh, the actual Workers' Compensation Act was codified or written into black letter statutory law, as you would say, in 1985, okay? There is a cap in place in terms of the cap on monetary benefits for permanently partially disabled individuals. That's anybody that is not 100% disabled, and in terms of how much money you can get for a permanent partial disability. And I'm not going to get into scheduled injuries and things of that nature, but the cap is $220.
Is that per week?
That's per week. And that was created in 1985. The cap has not changed since 1985, but our cost of living sure has changed since 1985.
Now that the table has been set.
All right,
I'm gonna ask you a couple questions and see if we can work through this. What was the minimum wage in 1985? Since the caps haven't changed since 1985, what was the minimum wage in 1985?
Oh, Lord. $4 or $5?
$3.25. Today, $7.25.
Whoa.
The cost of a Toyota Camry in 1985. You got an idea?
I mean, has to
See, I'd
be...
ask Allwin, except he's the one that came up with some of this stuff. But yeah, so he knows the answer to this stuff.
15 grand.
$10,898. Today, any idea?
I have no idea.
$24,000, almost $25,000.
Goodness gracious.
We could literally go through these from a gallon of gasoline to Oreos to fast food, which is near and dear to my heart, by the way. If I could still get a burger for $1.25 as
Are
opposed
you
to
kidding?
$6.50, yes.
Wow.
The point with all this is kind of a fun little deal that Allwin did, and I really appreciate it. And I know we put it up on our screen so people could see some of this stuff. The interesting thing is there has been a significant push, and Allwin has been involved in helping lead that push statewide with other lawyers that are involved in leadership positions to try and change those caps. Not change those caps so the lawyers can make more money. Change those caps so that the employees are able to make the type of money that is consistent with the economic changes that have happened since 1985. And I think that's generally the
It
concept.
is, and if I can give just a brief example, I mean, you know, I used a diesel mechanic earlier, someone that's been doing this for all their life, and they may or may not have, you know, another avenue to work. But let's just say their hand gets crushed. And as a mechanic, you can't do that without a hand. You have to have both your hands. But that's considered a scheduled injury. And this 220 cap applies on all scheduled injuries. It's scheduled members of the body. You know, this person has lost their vocation, their job, and they were probably making $15 to $25 an hour, $1,100 a week, and yet all they're going to get is $220 a week for 300 weeks for this injury when they most likely cannot even go back to work. Yeah. It's ridiculous. It doesn't justify. I mean, nothing's been changed. As I said, I mean, the cost of living has increased probably 200 to 300% since then. And like you say, there are a lot of good lawyers that do a lot more than I do that are leading this charge to get these caps changed, and it needs to be discussed. But you as an individual, you as an employee out there, you should approach your state representative and discuss this because it's an important topic.
And ultimately, the legislature, and I've been involved in some of those discussions, but the legislature is the one that ultimately has to adjust the cap.
They ultimately have to adjust the cap, and there have been, like I said, other lawyers that are really taking a charge on this that have actually gotten this to several committees up to the point of the legislature to determine whether or not how they're going to draft this, what trade-offs can be made with the insurance companies in order to get this passed. That's one thing that needs to be changed. In my opinion, we've been working under a 15% attorney's fee for quite some time. Many other states have higher rates. I think we should be bumped up to a 25% attorney's fee, because these cases last a long time, sometimes forever, especially when you're dealing with getting medical benefits paid after a case is resolved.
Time is flying, just about 3 minutes remaining, but a question I wanted to get to. I suffered a workplace injury. However, my employer told me I waited too long to inform them of my injury. Is there anything I can do? That's a question we have got from viewers.
Well, and as we discussed about the timeliness or the giving notice, you have the 5 days by statute, you have 90 days by law in which you should report the accident, or they can deem it denied or deny the claim. However, we fight those cases all the time and say the employer at least had constructive notice, or it's the employee's word versus the employer's word whether or not it was reported. Typically all claims are covered. There's some exceptions as long as it happened in the line scope and course of the employment. Even if it's your fault, there are some exceptions. If you were intoxicated or high on drugs, they do drug tests after you get hurt. They don't have to pay it. If you're in direct violation of a safety violation or safety rule, they don't have to pay it. If you're horsing around with an employee, wrestling, doing something, goofing off, they can deny the claim.
Right. I know we're getting close to wrapping up. Let me just do this because I'll kind of give my time up here. There are other claims that Allwin and I sometimes will work together on, which can be third-party claims that can arise out of an employment circumstance where the cause of the accident, the cause of the injury happens to be a mechanical component that was defective, happens to be another employer or a sub-employer that, or a sub-entity that is not the employer of the individual that was injured, but is on the job that may have contributed to the accident. All I would say is this, David. There are third-party claims. There are even claims called co-employee claims as part of the statute. Get to a lawyer, because you want the lawyer not just to evaluate your workers' comp case. Right. You want the lawyer, and Allwin does a very good job of this, of coming and evaluating the entirety of the case to determine if there's a third-party claim too that's not subject to the same caps, not subject to the schedules, not subject to the workers' comp act. That's an independent, standalone claim. So you want to make sure that you get to a lawyer quickly.
All right. Allwin, how about you? Just a final closing thought in just the minute we have remaining.
Well, I think that what Josh just hit on is key, because as an injured employee, you need to get to a lawyer, because just remember that regardless of the good relationship you have with your employer, the insurance company is taking the lead on this. Their main concern or focus is minimizing how much they pay on a claim. Don't let them bait you into agreeing to everything they want to do. Get a lawyer who understands the law. Furthermore, maximize your claim or your recovery, especially in the case of serious injuries, and let a lawyer look at it, find all the claims.
If you're sitting on the couch right now and you're concerned that filing a comp case or talking with a lawyer is going to impact your employment, don't be afraid of that. At least call someone. It doesn't hurt you to call someone like Allwin to be able to get questions answered. There are anti-retaliation provisions that will protect you.
It's free to talk.
Yep. It's free to talk, and in fact, the attorney's standing by right now. That number on your screen there. Be here for a few more minutes if you'd like to talk to an attorney about that. Now's the time to do so. Thanks so much for joining us. We'll see you next time. Have a great week, everybody. See you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.